So nice to see so many of you. I know the choices that have to be made are very tough, and I'm very happy that for you we have been the chosen ones. I want to start with some comments on the theme of this Agora and where it sort of stems from, and I want to do it with a brief example. So on the 29th of March of this year, Forensic Architecture, which is an organization based in London led by Eyal Weissman, created an investigation titled No Traces of Life, Israel's Ecocide in Gaza. And the investigation, and I quote, "The investigation marks Land Day in Palestine by examining the systematic targeting of orchards and greenhouses by Israeli forces since October 2023. The analysis reveals that this destruction is a widespread and deliberate act of ecocide that has exacerbated the ongoing catastrophic famine in Gaza and is part of a wider pattern of deliberately depriving Palestinians of critical resources for survival." They also described it as a form of herbicidal warfare. Now, why do I bring this up? The methodologies used in this investigation consisted of technologies of remote sensing, OSINT, cartographic regression, and 3D modeling. What we see here is the emergence of digital technologies that are deployed as forensic instruments in contexts of legal activism and demands for legal accountability. And it is sort of from this idea that this Agora emerges, the legal issues surrounding these technologies, their deployment, their openings, their possibilities, their problems, etc. We have three really fantastic papers to share with you today by Kaja Kowalczewska and Rafael Oitman, who will be presenting together, by Ellie Smith, who will present work together with Melanie Klinker on mass grave mapping, and by Matthew Gillett from the University of Essex. And the topics of their three papers, one is titled, and I'm abbreviating them a little bit, Documenting Human Rights Atrocities. The other is about mass grave mapping. The other is about digital evidence. So the words we see here, documenting, mapping, evidencing, what they point to is the use of digital technologies as new forms of witnessing, of bearing witness to something, and how these processes of bearing witness in legal processes and procedures are altering through the use of new digital technologies. So that's a little bit the context with which we're working today that I briefly wanted to introduce. And with that, Kaja and Rafael, I invite you for the endless walk to the other side of the stage.
Hello, everyone. Yeah, you can hear me. First of all, I would like to thank the organizer for choosing our paper and for Dimitri for this amazing introduction, because I can skip some parts of my presentation because you understand it all by now. So actually, the lacking word for the title of our presentation is whether we're gonna document those atrocities for eternity. And of course, probably yes, but the question is a bit different. So let me just introduce you to the background of our research with Rafael. And I'm gonna present to you the very complex slide that I prepared. But it's not as complex as the ICJ ecosystem is in practice. So in our work, okay, and maybe just one step back, so our research is motivated not only by the current developments, it's also partly motivated by the feeling of frustration, especially I personally observed what happened in Poland, country without experience in documenting that kind of atrocities in Second World War history. And this research is also partly contributing and getting inspiration from the research of Federica D'Alessandra and her colleagues, who are for several years calling for permanent investigative mechanism as a mean of streamlining the delivery of justice. So we thought that we're going to focus on one aspect of this ICJ ecosystem, namely evidence. And we had a look at different investigative mechanisms, and we went through 4 different types: UN or treaty-based bodies, especially human rights investigative bodies, ICT-based bodies, especially ICC, but probably some future tribunals as well, regional approaches, especially from Europe. And we tried to reach to other colleagues from other continents to learn what are the regional approaches, and we didn't, in their respective continents, we didn't really get much of feedback. So if you know any regional approaches to investigative mechanisms, please let us know. So here we focus on European, especially European Union, Europol, Eurojust, and Genocide Network. And then, of course, domestic authorities. So in our discussion, we include the effects of 2 major interconnected trends. Digitalization, I don't have to spare time on discussing the multiple consequences of that phenomenon, because this event is devoted to that. But I would like to just shortly say how democratization is an interrelated factor, because given the easy access to technology, many non-state actors try to leverage it to raise their own role within ICJ ecosystem to the more meaningful role in documenting atrocities, but also in regaining ownership over the conflict resolution and justice-seeking initiatives. So what we observed in Poland after the Russian aggression on Ukraine was that there were many NGOs that had previously experience in documenting ICL violations because they were just focused on peacetime human rights violations, and they started to engage with the masses of victims and survivors coming from Ukraine. On the side note, the same thing is happening this year with Polish citizens from Gaza. And so those NGOs, they collected information, and some of them could transfer that to authorities, domestic, ICC, to the less extent to Ukrainians, but some of them decided to create their own repositories. And that has also multiple consequences for the whole system. So we see this democratization and digitalization as interrelated factors, And to that, we need to, of course, add the recent policy on complementarity and cooperation of the ICC, in which the OTP recognized that, restated the principle of complementarity, also saying that there is a need of participatory approach in ICJ, of combining efforts of many actors, including non-state actors, and in this, let's say, system thinking approach to ICJ, OTP acknowledged that different elements of that system don't have all the resources, all the possibilities to effectively prosecute ICL violations. So what we had look at is the evidence. So all of those bodies, including non-state actors, are engaged somehow with evidence. And in our paper, we treat this evidence in a very comprehensive manner, including traditional, user-generated. Yesterday, it was coined by Frank as SMOs, so social media, open source evidence, everything that is being collected currently. And repositories, believe me or not, but all of those investigative mechanisms have their own repositories. NGOs, to some extent, create their own, but they also join efforts in some kinds of coalition and build their own repositories. And of course, ICC has invested huge money in Project Harmony and its technological platforms. So all those repositories, they have different methodologies, different technological solutions, different staffing and funding. So to that, we want to add, not to that, but we think that there is a need of the joint comprehensive archive, or whatever we call it, something that's going to streamline the work of all of these elements and will reduce costs. So here we want to just acknowledge that we don't underestimate the completed and ongoing efforts, like of all those mechanisms. We also don't have a one and only blueprint. We want to discuss with you today and collect some insights on the factors that we need to consider when we talk about some kind of unified comprehensive body to collect, verify, and archive evidence on global level. And of course, we understand that this cannot be created overnight, but the discussion probably is already on for some years, and we need to stress it more. So in our research, in the paper, hopefully you will be able to read how we went through all those 4 investigative mechanisms and check their mandates, methodologies, modus, and mutuality, meaning coordination agreements between all those mechanisms. And we have some preliminary results which we want to share with you. So there are overlaps, of course, in the mandates. And probably the Ukraine case illustrates that in the best manner. Many different bodies are prosecuting, investigating same crimes, same situations in different manner. Of course, we also know that international crimes investigations are very complex, and more and more we acknowledge that the contextual evidence, which is not evidence targeted at specific situation or a person or crime, is also very relevant. It's illustrated, for example, by German structured investigations on domestic level, and usually actors need to reach out to other actors that are in possession of that information. What we have seen with the research is that there are some coordination efforts. They are growing, but they are mainly based on bilateral agreements. So imagine the big, this bifurcated ICJ ecosystem in which all the elements have links on bilateral basis, and try to map whether all of them really cooperate or not. We believe like the bilateral agreements, which have different terms and conditions, different approaches, it's really hard to see whether the same information that is collected by ICC and domestic and, for example, UN authorities is available to the victims and for justice processes. And of course, last but not least, the very practical part, so the silent rivalry over the ownership of information and technology. And I think the best example is are the current developments at the EU level, where Eurojust is developing something called CSET, the centralized database of evidence, while Europol, which is a brother or sister organization of Eurojust, has a robust database which also covers international crimes. So there is an important overlap, and you can imagine that this is closely linked with some concerns about job loss, loss of funding. And here I gave the example of public bodies, but the same argument applies to NGO sector, where some NGOs are created just for the sake of creating a technological development, a solution, a tool, or some of them are developing that tool and are struggling with financing the storage of the data over, we know, many years when investigations will happen. So we ask whether it's time for a centralized solution and to minimize this unstructured and probably less effective coordination in ICJ. So as I already probably mentioned many times, so our blueprint is to create one body that will collect, verify, and archive information on evidence of international crimes, and that will be made available to different authorities on different level. That would help to eliminate some duplications, to decrease costs, which are very I would say, very high, although I didn't have access to any statistics on how much does it cost a citizen or a country to conduct investigation into international crimes. We only know about the budget of ICC, yeah? But it's also hard to say how much does it really cost. And to enhance the interoperability, to allow domestic jurisdictions to be more effective. So the desired outcome would be that the domestic jurisdictions, which should be the primary actors responsible for prosecution of international crimes, but are under-resourced, unexperienced, and sometimes unwilling or inactive to prosecute, with help of that kind of access to the one unified repository, with assistance from the ICC as announced in the complementarity and cooperation policy, and regional assistance as at the EU level, and inclusion of non-state actors would be, the domestic authorities would be more prepared, or they would have better conditions to deliver that kind of justice. So we understand that that kind of initiative requires, first of all, careful planning. We know that technology have many risks and benefits. So by design, we should consider many interdisciplinary political, technological, psychological, legal factors. Of course, robust financing should be provided. Skilled staffing, probably staff from existing repositories could contribute with their experience to that kind of mechanisms. And we believe that commitment to interoperability, witness protection, and transparency would be the most important. And please, Rafael, join me, because Rafael will show you what is the proposition in the remaining time of 1 minute 30. Sorry, Rafael.
This probably have earned us another 30 seconds or so. I will be very quick in terms of actually trying to kickstart us and the subsequent discussion as to what we could imagine as one, as Kaya said, blueprint, which is of course just like an idea that we would like to throw out in the open. So what I think has become clear from what Kaya has presented already is that if we actually would think or agree to think about such a thing as the JCA, what this would definitely need to fulfill is it would need to be impartial, right, and somehow detached from, you could say it like easily from everyday politics and political skirmishes, and we all know how difficult that actually is. And then the question would actually be, from an institutional perspective, also from a practical perspective, where to host such an institution, such a whatever kind of JCA. And one idea that we came up with, or that we would like to throw out into the open and would like to discuss with you, is that the first international organization that we would think about, of course, is the United Nations. And I don't want to go through the specifics of the charter. You all know them, I suppose, that there are certain ways by and through which such an institution of whatever kind in the end could be created under the auspices of the charter as a subsidiary organ of the General Assembly or the like. You could actually put that under the control of, for example, some form of Undersecretary General, all just some very lofty ideas. But what would be the important thing, and this is also with what I would like to conclude, knowing that the time is running out, there are these three dimensions that we have put at the end here, which I think, or we think, are crucial. On one side, it's about external relations, with what here we actually refer to all these kind of exchanges with those authorities, with those mechanisms, with those initiatives that actually collect evidence of these different kinds, and to make sure that they are actually come towards this particular repository body. Secondly, and this is, I think, one of the most crucial aspects, we all have heard about that when Dimitri mentioned forensic architecture, or Bellingcat would be another example, these initiatives that actually spend an enormous effort on verifying digital evidence in particular, make sure that if we proceed with these kinds of evidence, these can be used, and that these forms of evidence are court-proof, so to speak, so that they actually adhere to standards of proof that we actually have, for example, in front of international criminal courts and tribunals. And then thirdly, and this is actually the more logistical, practical dimension, is in the end of the day, there would need to be some form of storaging, archiving this kind of evidence, mainly and more increasingly digital evidence, but also other and more traditional forms, with the overall aim in the end of the day to make sure that we don't have what we could call investigative gaps, and that due to the fact that there is too little, well, interchangement of these kinds of evidence, in the end of the day, international crimes would go unpunished. And with that, I would like to thank you very much, also on behalf of Kaya, and we look forward to the questions that hopefully come up in the Q&A. Thank you.
Thanks so much, Kaya and Raphael. It's a really interesting and helpful overview of this evidentiary ecosystem, and also for giving us a very concrete proposal for documentation and archiving that we can discuss together afterwards. Ellie, I invite you to the stage.
My name's Ellie Smith. I'm Senior Research Fellow at the Mass Grave Protection and Investigation and Engagement Project, or MAGPIE, that's based out of Bournemouth University. I'm a lawyer and a victimologist. And I'm here today to talk about our recently completed project MAGMAP, but also to introduce some of the work that we're now doing under our new project called MAGPIE. So the purpose of MAGMAP was to understand the advantages, the disadvantages, and the challenges involved in mapping mass graves in an open source format. So broadly speaking, our work involved examining the various assumptions that underpin open source publication where it relates to human rights protections. And we then looked at those in 5 country case studies in situations where there have been sort of mass grave challenges politically and geographically. Just to see how those assumptions played out in practice. And from there, we produced rather 3 online digital tools that would aid the decision-making process of mapping mass graves. And I'm attaching here, there's a link in the bottom, or at least a web address if anyone is interested in exploring those a little bit on the website. There's a flow chart, risk register, and a decision tree, and they literally went up yesterday. I think one of them might need a little bit of manoeuvring still, but it's very much a very, very recently finished project. There's also hard copies available out on some of the tables out in the coffee room, and I really urge people to take them because it will mean I don't have to carry them back home with me to the UK, and I only have carry-on luggage. Unfortunately, my colleague Melanie Klinkner isn't able to join me today, and she had overseen some of the more technological aspects of the project. So I've picked her brains as much as I can, as well as talk to our data research scientists. So hopefully I'm going to be able to cover those, but forgive me if I'm fall a little short on some of those. And also, we also piloted our tools on Ukraine shortly after the Russian invasion, as mass graves began to emerge there. So I'll try and tell you a little bit about our pilot there as well. So turning to the MAGMAP project and our rationale for it. Mass graves are, they're evidently sites of horrendous suffering, but from a legal point of view, they're hugely significant sites in as much as they contain all the information that we need to obtain formal legal identification of bodies within them, so that they can be returned to families and help to realise their right to truth in respect of how their loved ones died. And they're also hugely significant because they're crime scenes and they contain a lot of the evidence that we need to pursue accountability. In terms of scale, mass graves can be found on every inhabited continent, and the numbers involved are frankly staggering. So in Iraq alone, up to 1 million people are currently missing, suspected in mass graves, following decades of conflict and human rights abuses from the Saddam Hussein era to the Yazidi conflict. In Bosnia and Herzegovina, we've got 7,600 people still missing, and that includes 1,000 people from the Srebrenica genocide, again, likely in mass graves, still being unaccounted for. But despite the huge significance of mass graves in evidential and informational terms and the huge scale of mass graves, there isn't a global system of record keeping of where those sites are located. And in 2020, the then UN Special Rapporteur Agnes Kalamar called for the regularized mapping of mass graves. So in part, what MagMap was to find out what regularized would look like in that context, in the context of mass graves. So why is mapping important? The first thing to note about mass grave investigation is that while we see an awful lot of mass grave investigations and exhumations ongoing to support criminal investigation, exhumation, and identification is not the norm. For most people who are looking for loved ones in mass graves, their remains will never be found and there will never be a case brought before a court. And that's even when the existence of sites is known about. And the reason for that mass graves exhumation is time-consuming and it's expensive. In Iraq, for example, based on the number of mass graves that we currently know about and the rate of progress, it would take 800 years to exhume and investigate those sites. Mass grave exhumation and investigation also involves a huge amount of political will. So, for example, in Guatemala, the conflict there ended in 1996, 36-year conflict. There's still no specialist body that's charged with the search for the missing and the exhumation of mass graves. 45,000 people still missing there. And where a mass grave, or the existence or the very presence of a mass grave, runs counter to political ambitions or nationalistic goals, they become very, very inconvenient reminders of an uncomfortable truth. And we've seen this at the moment in Bosnia and Herzegovina, in Republika Srpska, where, for example, we're seeing a lot of memorials springing up to Mladic in Foka, and we know that the children who attend school in Republika Srpska haven't been taught since 2016 about the siege of Sarajevo or in fact the Srebrenica genocide. So there's a revisionism going on there as well. And of the 42 largest mass grave sites in the country, just 12 of them have any kind of marking, a plaque or anything to indicate that they were mass grave sites. So for those people who are looking for their loved ones or for justice or both, we need to find some other kind of way of meeting their justice needs. And while physical memorialization of mass graves may be difficult, the digital recording of sites, especially when it's an open format, might provide some help. It can also provide some kind of protection of a site. So, for example, where political situations change, if we know now where a mass grave is, it may be that in decades to come, we can go back and it can be investigated. So we see something similar, for example, in Guatemala after years and years of conflict. Last year, they elected a new president on an anti-corruption agenda, and we have a former army general who is now being tried for genocide before the national courts. They're running out of time. The defendant, I think, is in his 90s, and his co-defendant's been declared unfit to stand trial. But there's still the prospect there that if we know where those sites are, we can return to them at a later date. And we can also use maps to plot patterns of violations and potentially to identify possible locations of mass graves that haven't been found, if we can identify a modus operandi, if you like, of how bodies and where bodies are disposed of. So as you can see, there's clearly potential advantages of open source mass grave mapping, but the issue isn't a straightforward one. So I've spoken already about the significance of mass graves, not just in terms of the information that they provide for identification, but the evidential content. And when we have a mass grave site, a crime scene, if we were, for example, to declare it's a awareness of its existence in an open source format, there's the potential, particularly where perpetrators are still in positions of power, that there will be the disturbance or destruction of a site. And that obviously involves damaging evidence, and it also involves the damaging separation and commingling of body parts. And we saw this in Bosnia towards the end of the conflict, where the Secretary of State announced in 1995 that he was, through satellite imagery, aware of the presence of several mass graves. And those mass graves were subsequently dug up using heavy machinery, and bodies were moved in their hundreds to much smaller sites, to secondary sites. And the result is that those body parts were separated. We have the ugly spectre of women, mothers in Srebrenica, for example, having body parts returned to them from 4, perhaps more, secondary mass grave sites. So it's hugely traumatic for families when that happens, and obviously damaging for a criminal case. And public disclosure of a site can also put witnesses at risk and families themselves at risk. So our aim in MAGMAP was really to see how we might navigate some of those challenges and chart the decision-making process about when something could be put on a map. And when mass graves were reported in Ukraine, we decided to pilot our 3 tools on the situation there. And it was incredibly helpful just to see how mapping worked or didn't work, what the challenges were trying to do it in real time. And what we found was the volume of evidence was overwhelming and conflicting. There was the potential for misinformation. We had numerous reports, potentially of the same mass grave, potentially not, slight variations in numbers, in site locations, and the challenge of verification was hugely difficult. Sites moved very, very quickly from being reported to being excavated, exhumed, identification. So if for anyone who, for example, is wanting to produce something other than a pin on a map, where you can actually click on something and get something meaningful in terms of information, the turnaround was huge. And we also found that there was a real paucity of information available in Russian-controlled areas, with the potential that that could then lead to a map that was skewed, and that in itself could feed into a revisionist narrative. And also we found that as there was less and less information available in open source format, as the media lost interest, frankly. So that's a very, very brief whistle-stop tour of MAGMAP. Where we're going now, we have a very small team of data researchers, and using the tools that we developed, we have begun the process of producing the first worldwide open source map of mass grave locations. Continuing challenges that we're encountering is the verification of reports and data. So we might go from something, for example, where it's been reported in court documents and it's been investigated. There's no challenges there in terms of the site, because it's already been investigated, and there's no prosecution risk because that's already happened. All the way through to something that's perhaps more almost bordering on anecdotal, how we apply consistently verification standards, how we work where there's limited access, all sorts of other areas, cross-referencing, where, so there's a number of different mapping projects that have been undertaken in different places, different challenges there. So what definition of mass grave do they use? What's their naming convention? What details do they use? So we're in early stages, and we're still kind of, I suppose, finding our feet on it. And I think it's probably another couple of years' work, but hopefully we will have something to report again in 2 years' time.
Wonderful. Thank you so much, Ellie, for exploring with us these political questions and ambiguities around mapping, and also the link between mapping and memorialization, which I find really interesting. Matthew, the floor is yours.
Okay, good afternoon. And I don't have a PowerPoint, which maybe bodes poorly for a presentation on digital evidence. Apologies for that. As you've heard, digital materials and new methods of collecting information are becoming pervasive in the investigation of atrocities and widespread human rights violations. And building on some of the information that's already been provided, I'm going to try and transport us into the courtroom and explore how this introduction of technologically generated and collected material can actually potentially transform the epistemology of forensic practice, the truth-forming function in the courtroom. In various proceedings, and certainly through my professional experiences at the Yugoslav Tribunal and then at the ICC, I've seen firsthand the major increase in the amount of digital material and techniques being used as part of prosecution cases and, of course, by the defense and other parties to proceedings. So, of course, there's the Al-Wafarli case, which was essentially built at its core on videos uploaded to social media of purported executions. We also saw recently in the International Court of Justice's provisional measures order in the South Africa-Israel proceedings about Gaza that they relied quite centrally on tweets by high-level Israeli officials, which is something quite relatively unique. I don't know if it's the first time the ICJ has ever referred to tweets, but certainly I would suggest the first time placing such a strong emphasis on that type of material. I've also seen this in my work at the University of Essex, where I lead the digital verification unit, and we have a group of students very diligently and determinedly contributing to investigations, and there's an increasing demand for this type of skill and analysis, which then feeds through to proceedings, feeds through to collection of evidence by commissions of inquiry, but also to international courts such as the ICC itself. And it's got to the point where whenever I see a new team forming with a new commission of inquiry, etc., if you look among the skills and attributes required in the bullet points, you will often see digital technical skills as one of those listed points. So it's a really important growing area which suggests there's some true promise. At the same time, my question, which I've been asking myself in this paper, is this a true revolution, or is this another turn of the technological wheel? And to test that question, I've been reading back into when DNA evidence first made its way into criminal proceedings, and how that shook up and tested that traditional dynamic of fact finder visually and physically being in the presence of the witness in many instances, and almost organically forming a sense of the truth and credibility of the statement being provided to them. Now, obviously, DNA evidence doesn't speak orally. Nonetheless, people such as Robert Boyle have called this kind of evidence the testimony of nature. And there's an interesting question about, will this come to effectively replace witness testimony in its entirety, given that, if well preserved, it doesn't degrade over time, and in fact can tell you more and more as scientific, technical techniques advance. Looking at the way DNA has been used, we've seen it probably most, in a well-known sense, used in innocence projects where hundreds and hundreds of imprisoned people have ex post facto, often decades later, been shown to have not been convicted on a safe basis, potentially that was incorrect identification or other reasons to believe they may not have been responsible. However, it does cut both ways. And in 2003, Mitt Romney, former presidential candidate, but then governor of Massachusetts, had said that you could set up a guilt process so that science could be used not only to free the innocent, but also to identify the guilty. And so that highlights that it's a type of evidence that can be very powerful, but also should be used with caution to make sure that it is not overly relied on. In terms of the lessons that emerged from DNA use in the courtrooms, we saw that in its early days, there was quite a considerable amount of statistical information that needed to be explained to the courts. There was a number of genetic population assumptions that were made that sometimes turned out to be incorrectly formed. If the population database, for instance, was based on a European genetic profile, and then you had an accused who had a different ethnic background, you might get a false impression as to the likelihood or the lack of likelihood of that person being identified at the scene of the crime. So there were those early teething problems that arose, and in the analysis, the techniques used, there were also teething problems in the handling. So there was laboratory errors, there was errors made by police detectives in collecting the evidence, mislabeling, potentially cross-contaminating with other samples. And over the iterations of use of DNA evidence, these problems then transformed into further administrative safety checks. So you saw a transformation of more or less ad hoc investigative techniques into safeguards, which have then led to DNA evidence being relatively standardized in its use in the courtroom today. We can actually go back even further and look at fingerprint evidence, which is still used these days, although far less frequently. And in its day, in the sort of 18th century, early 19th century, fingerprint evidence was seen as the gold standard. It was accepted as a form of factual evidence, as distinct from witness testimony, based on Locard's exchange principle that every contact leaves a trace. There was this sense that you could know in an objectively truthful way as to a person being present at the scene of the crime. However, we found, of course, that there were problems. Fingerprint evidence turned out to be valuable in several ways. You could get mismatches, you could get mistaken contamination, etc., through the investigative process. And there was also a certain illusory presentation in the courtroom. For instance, fingerprint evidence was given this special status, this epistemological, heightened, elevated standing, but at the same time, under different jurisdictions, you had, for instance, different points of matching that had to be adhered to. So in the UK, it was 16. In other jurisdictions, it was less or more, which suggests it's not such a objectively unquestionable type of information, and that there is a level of subjectivity. Looking at those past technological revolutions and then comparing them to digital evidence, I find there are differences in the sense that digital evidence not only can tell you who or what might have been present at the scene of a crime, for instance, it can also actually, in a way, bring the fact finder to the scene of the crime. So if you think about the videos of Bucha in Ukraine, which were used in the New York Times investigation, you could actually see the detainees being frog-marched hand in hand. I think there were 8 or 9 of them. And that really takes you in a way that reading a witness statement will not quite have the same immediacy, and not quite allow the same level of direct observation. Nonetheless, there are threats and there are dangers, because hidden behind that apparent objectivity, there are editorial choices that are made by whoever's capturing the footage, or even if it's a CCTV camera, whoever's placed that camera, and the person who may have downloaded, uploaded, transferred, and potentially even altered or adjusted that information. We, of course, are hearing more and more about deepfakes and manipulated digital evidence, and in that respect, we're seeing something of a technological arms race developing between investigators trying to keep up with the latest techniques of adjusting materials to make them seem real and misascribe conduct statements, other forms of relevant activity to persons. We also see a challenge, and I think this harks back to the previous presentations, of this overwhelming body of material that is being generated on a daily basis. If you think about Ukraine and the terabytes of video, other forms of content that have been uploaded in various ways on social media, but also provided to all of these bodies. And thinking back to the days at the court where evidence has to be registered, analyzed, potentially disclosed to other parties, this puts a huge burden on the court. And I imagine that a lot of the impetus behind projects like Project Harmony are to be able to try and make this more efficient and avoid the court being swamped with so much of those technical aspects that it can't conduct its primary mandate of investigating and establishing responsibility or lack thereof for atrocity crimes. Finally, the other distinction I would see is that digital evidence has a more dynamic nature to it. DNA, essentially, of course, it can mutate over a lifetime and generations, but as an entity, doesn't change. Digital evidence is changing all the time in its nature, in its scope, and in what we can learn about it. So there is a distinction there. Turning to some of the lessons and the more operational side, any guidance or parameters for the use of digital materials in court proceedings necessarily needs to be quite broad. Obviously, DNA or fingerprints is quite a confined type of material. Digital evidence is far broader, and different types can require a different measure, different regulatory approach. At the same time, the International Criminal Court is going to struggle to have 1,000-page guide manuals that are adopted into binding forms, rules of procedure or regulations or some other kind of document. And so there is going to have to be a level of flexibility to convey the principles and direct parties in the right way. I also note that the court and other bodies dealing with this type of material should strive for clarity and avoid obfuscation, ensure that they transparently explain how these materials are being used and any limitations thereof. Also, potential human rights implications should be borne in mind, privacy, etc., and how the use of this material could undermine those rights. There are questions about the appropriate type of regulatory instrument that should be used. As I mentioned, is it feasible to have amendments to the rules of procedure and evidence to cover such a dynamic and broad-ranging type of evidence? But if we content ourselves with, for instance, guides by civil society, etc., which can be very useful, very detailed, does that really provide parties, and particularly accused persons whose due process rights are really sacrosanct, with the kind of certainty and fairness which they are entitled to under international human rights and under, for instance, the Rome Statute? And finally, my point that I come round to is that experts will play an ever greater role in explaining and interpreting this type of material to the fact finders, whilst at the same time, judges themselves in particular should not shy away from trainings, from understanding this type of material, so that they, in the courtroom and during their deliberations, can assess it and can help themselves to make the best use of this type of material. If we turn to the broader epistemological question, there is an adjustment that's occurring with the fact finders increasingly conducting that function based on materials generated and outside the courtroom and not necessarily tested and not necessarily testable inside the courtroom. But at the same time, I would see this as a step, an adjustment, rather than a seismic change to the entire infrastructure of courtroom forensic epistemology. With that, I will leave it for questions, and thank you very much for your attention.
From the audience, you cannot see this, but we have a timer in front of us on this screen, and Matthew stopped on the very second that the time ran out. So, incredible precision. A really fascinating account on epistemological hierarchies and the authority and power of truth-telling. The quote you used, the testimony of nature, from someone you quoted, I don't remember who, really stuck with me because of the post-humanist panel before as well. It's a really interesting line and maybe worthwhile thinking about more as well. I realize you've all been listening attentively, quietly. So before continuing our conversation, I would very much like to give you the floor for questions, comments, interventions. Okay, we have one person here already.
Very much. I'm Joe Powderly from Leiden University. Really great panel, and I think builds on quite a few of the discussions we had yesterday in the Criminal Justice Interest Group. But I have many questions, but I first want to start with Kaya and Raphael on your paper. So I'm sort of wondering whether you think it should be taken for granted that digital evidence is overwhelmingly a positive thing. And I'm wondering as well whether, you know, in jumping quite understandably towards the creation of a global entity that will be tasked with archiving this information, this evidence, that might be given the task of verification, of authentication, of geolocation, and all the other Asians attached to it. Maybe we're glossing over some very profoundly complex questions of morality, ethics, and so on. For example, I'm wondering about the idea of a global entity that archives digital evidence and digital information, about what this means about the consent of victims to the archiving of this information. What does it mean to the family members of the victims of these crimes, that we have a global archive of information, of representations of violence and perhaps lethal violence for these individuals? And this goes to the agency of the victim and ownership over what has been done to them, representations of that harm that they have suffered, and how that representation is used in legal proceedings. I'm also wondering about the long-term status of this information. What about a century from now? What happens to this information? Will it become basically sort of an ephemeral artifact of violence, that it will be stored and lost at the same time, a bit like that scene at the end of Raiders of the Lost Ark? We will just have this storage of digital representations of horrific things, but no one's doing anything with them, and yet they're there and not there, sort of a Schrodinger's digital evidence, so to speak. And then finally, and this is something maybe Matt might be able to talk about as well, aren't there serious issues about over-relying on digital evidence in criminal prosecutions? And my sense is that for digital evidence, it typically goes to the establishing crime-based evidence. But in international criminal prosecutions, rarely do we have a problem with establishing the crime base. The real problem goes to linkage evidence and connecting the accused with the violence that we're witnessing in these digital representations. So the digital evidence doesn't necessarily help us in securing prosecutions. And I'm also worried about the fact that maybe with the reliance on digital evidence, we're moving further and further away from the orality of international criminal prosecutions, from receiving evidence from victims of witnesses in person to give them, for want of a lesser cliche, their day in court to look their accuser or the perpetrator in the eye and give their account. And related to that is the idea that maybe we're in danger of relying on representations of violence, simulacra of violence, rather than direct evidence of violence itself. So I hate to be the person in a conference that's very much about technology and international law, but maybe it's not overwhelmingly the positive thing we want to make it out to be. So thank you.
Wonderful. That was almost a beautiful paper in its own right. I also think that in addition to the Monograph Prize and the Young Scholars Prize, there should be a prize for someone who gets Indiana Jones and Schrödinger in one sentence. But a really beautiful question. I want to do one thing with it, because it's addressed to Kaya and Raphael, but I think it speaks very interestingly to questions of memory and memorialization. The question, the moment you say, we basically have a permanent record of horrific things that sticks to us and stays with us, and what does that mean? I think it's Ellie, it might speak to you as well as to the questions of kind of what do we value epistemologically, and you mentioned human rights issues as well, where the kind of victim concerns come in. So it was so broad and rich that I would maybe do a tour de table just with that material.
Since you actually came up with Indiana Jones, I have to take this question. Huge Indiana Jones fan myself. I probably should start by saying that I completely agree with you. I'm actually not in favor of saying that digital evidence is going to be the only way forward. Quite the contrary. So the rationale behind the paper actually was to say we see that as Matthew also said, we have this like this massive body of digital material evidence, whatever we want to call it, that is there, and we somehow have to deal with that, right? And I think in the end of the day, most of those points that you also mentioned come down to the question of can we use it properly, meaning can we verify it, and so actually complement all the other kinds of evidence that we have, and I think we should maintain to have, and somehow corroborate. So I wouldn't say that the future of conducting international criminal trials is actually by only focusing on digital evidence. I very much like what you said about the orality of international law. I think everyone, and I guess some here, have somehow been sitting on judges' benches, be it at the moot court or in some other function. And then you see that the orality within the criminal proceeding, within any kind of trial, that there is something to it. And this is, I think, something that can and should not be replaced. And so I would always advocate in terms of saying that digital evidence is accompanying these more traditional ways or these more traditional forms of evidence, and not supposed to replace it. Regarding the question of, and this connects to whether it's a good thing or not, this question of morality, ethics, and then ultimately also the question as to what does that do to victims and to relatives. So one of the ideas when we started about thinking, proposing this JCA, which is just like one way of thinking about that, was to go back. I'm not sure whether you are familiar with what is called the Arolsen Archives. So that's something hosted in a small city in Germany, which is a documentation center for crimes committed during the Nazi tyranny, during the Nazi dictatorship. And so this actually is an archive where lots and lots of traumatic material in that sense is stored, and where researchers, but also, at least possibly, criminal investigators can resort to in order to corroborate information, in order to cross-check, to verify, and so on and so forth. And this actually is sort of like the guiding rationale behind. Of course, in terms of practicalities, there are immense challenges when it comes to safeguarding that there is no re-traumatization of victims or families, to make sure that personal rights are safeguarded. So it's not meant to say that, well, we just create another international body of whatever kind, and so this is the way forward, and this is the only answer. But this overall idea only stems from the very fact to say, and this actually brings me back to Indiana Jones, to say, of course, there is this this image of this huge hall with all these repositories and all these little boxes. The question really is, what are we supposed to do with that? So do we only put it there and forget about that and just keep it for the sake of it, or do we come to a point of saying that through cross-checking, cross-corroboration, we actually we get better at conducting investigations, at also bring them to an end and to either an acquittal or a verdict, that we not get lost along the way for whatever kind of reason, in order to make this whole enterprise, which is international criminal justice, more effective, to give it more vigor, I would say, and to become better in terms of this overarching theme that we all know, to end impunity for the worst crimes imaginable. And so I think that in this case, as an accessory, probably, digital evidence can play quite an important part.
Short passage to Ellie. So I would just relate to the comment on eternal storage of violence proofs. So I would say in our research, we also had a look at the full name is I don't remember, but the residual mechanism. Yeah, you have an online collection with photos, videos, interactive for educational means. You have also the investigative part, which is closed access, right? And in Poland, in a state victim of 2 totalitarian regimes, we still have 2 big archives documenting those atrocities. And I believe the proposition that we wanted to show is one part of those investigative mechanisms is criminal proceedings, but the other is education, historical inquiries, familial inquiries. And here I pass to Ellie.
So we've heard from some amazing lawyers. I'm going to answer the question as a victimologist, if I may. But just one point, I think a lot of the information, if it will be out there in a kind of an open source format anyway. Oh, it's not? Okay.
Maybe just a small disclaimer, that wouldn't be open access. That would be available upon some motion only to relevant authorities.
Got you. So looking at the memorialization aspect, obviously when reparations are awarded to victims, there's often an element of victim involvement in the form that those reparations would take. And so my feeling is that an archive per se wouldn't necessarily function as a form of memorialization, but equally I don't get that that's your goal in pursuing it. I think as well, looking at when Matthew was talking about the volume of digital material, to the extent that it could almost kind of replace witness testimony, I think we have to remember who is justice for, and I would agree with you, Joe, in that for a lot of witnesses, being able to speak in court is a form of justice in and of itself. So in that respect, a justice need might be, well, I need to tell my story, I need to be heard, I need to be understood, I need someone objectively to tell me that what happened to me was wrong and my pain is legitimate. And to that extent, a court is a vehicle for realizing that goal. It's not the end point, it's a vehicle for realizing a justice goal in a victim. And what we're actually trying to achieve through the court process for victims is a sense of justice. So you're effectively trying to achieve something psychological in the victim. You're trying to achieve a sense in them that justice has been done. And I think trying to do anything in in international criminal justice without victims, if we look at the kickback that we had on the ICTY, from the ICTY and the ICTR, and the limited engagement from victims, you start to get victim disengagement and from those tribunals, and that eventually has an effect on the perception of the legitimacy of the judgment. So my sense is you can't have international criminal justice without victims, nor should you. But I also totally see that there's a huge role for digital evidence within that scope. I think it's a really, really interesting balance to be struck.
Thanks. There's a lot in your question. So I'll approach it from a forensic perspective. And even from that, let's say, quite dry perspective, I think witnesses, human witnesses, will always have a role, for instance, for matters such as psychological harm that they've suffered, which is an element of various crimes, for intent. If you think about trying to prove genocidal intent, etc., it's pretty rare that you'd get a document containing that kind of incriminatory information, and a lot of it will come from insider witnesses who can help explain how certain decisions deviated from standard operating procedures, the type of material that can really lead you to identifying, okay, who were the key perpetrators here. So I think there will always be a role for witnesses, and I'm personally, having taken witnesses, I think it's a really important function of especially international criminal justice. What I'm interested in epistemologically is the courtroom's role as a crucible of justice. And I use that term in the sense of a space, physical, or if it's a video witness, virtual, where the fact finder has the opportunity to assess the veracity or not of the account being given to them. And there I think that the digital evidence can help, even with an individual in front of them, because they may have cell phone data, they may have other digital evidence that can be used to confront them, which may help confirm. They may have a plausible, convincing explanation, or it may undermine or challenge or alter their narrative, their account. So I think there's a very important role. And then equally for the digital evidence itself, it's not generated in a pure vacuum. Of course, science pretends or would like to be purely neutral and unbiased, but decisions are made when you set up any kind of experiment as to what the parameters are, what information is fed in, and what results you will be looking to comment on. And so in the courtroom, there's that unique aspect of the fact finder almost being present while the experiment is redone, if it's an expert witness, explaining the steps of their experimentation and potentially being subjected to quite harrowing cross-examination or testing cross-examination from a skilled advocate. And that, to me, can maintain the unique role and the added value of the courtroom and avoid a situation which we've seen with, for instance, media articles where certain things are reported as fact that have then turned out to not reflect fact. And it's led to the International Court, for instance, having quite a healthy dose of skepticism about relying on media articles per se. And of course, no one's infallible. UN reports, similarly, there can be mistakes in there. So having that added check and balance, and again, for fair process rights, it's very important, but also for coming closer to the truth. It's important for victims as well that you can use the process in that way.
Great, thanks so much to all of you. And again, to the question, I turn back to you, this dark mass in front of me. Okay, great, go for it.
A very quick one from Matthew, actually. So you, what I very much liked, you said, so we're gonna, jump into the court or into the courtroom and actually take the court perspective. And what I instantly thought about was, are we equipped, procedurally speaking, to deal with whatever kind of digital evidence we are faced with, let's say at the ICC? So the OTP, has set up this OTP link where, with regard to the situation in Ukraine, individuals can upload material, videos, photos, whatever, where this is collected by the Office of the Prosecutor. We still have the question as to verification of these documents, these materials. And I was just wondering what your take would be. You mentioned the rules of procedure and evidence, and actually, if I get you correctly, advocated for a, let's say, a flexible approach towards, what can we accept as evidence, how can we deal with that? And I was just wondering, do you see any need, so if we take that, through a proper trial at the ICC, where we have to deal with certain standards of proof regarding, let's say, the quality of evidence. Do we need any sort of reform in that respect in order to be really able to make use of these, let's say, new means of evidence more thoroughly within these long and very complex proceedings? So are we speaking as international criminal courts, in this case the ICC, are we fit for purpose when it comes to make use of these new kinds of evidence? So I would be very interested also to hear from your practical experience as a court officer.
I'm hoarding mics so I can pass some along.
Adjustment is required to the normative framework at the ICC, in my personal opinion, in one respect relating to expert witnesses. At the moment, the test for experts is just based on the jurisprudence. You can look, for instance, and I think there's an Interganda decision which effectively says it is a person of specialized skill or knowledge. And there are some other complementary strands of jurisprudence, such as that they shouldn't usurp the function of the trial chamber and reach ultimate determinations that are dispositive of the case. They shouldn't exceed the parameters of their expertise. And there's been some other guidance, but it remains non-binding on any other trial chamber and very vague and hard to really establish who would or would not be an expert. And I think what we're seeing with digital evidence is there's a lot of amazing work being done through amateur efforts, but nonetheless can be of an expert quality. At the same time, there can be established highly qualified people who may not have the expertise to deal with recently emerging technology. So I think, yes, in the area of expert, there does need to be some regulatory additions, refinement. I think it's very challenging when it comes to how you formulate them precisely. And then more broadly, yes, in relation to digital evidence, I think in the way of strong guidance, as in guidance in the normal course of events, the material, for instance, will have already been made available to the other side. The court will ensure the other side has the technological means to test the evidence, because I think there's a real access to sophisticated methodology question there, which can create potentially unequal proceedings. So some of those types of safeguards, I think, could be more clearly reflected. And there are a number of different instruments that you could look at amending, but the higher the hierarchy from the Rome Statute and Rules of Procedure, the more difficult, because then you have to involve the Assembly of State Parties, which I shouldn't go too far astray, but in my view, of course, the court shouldn't be afraid of going to the Assembly of State Parties. That's its function. But at the same time, it's not designed to deal with necessarily the minutiae of sort of everyday procedure of the court. But the short answer is yes, I think amendment and reform is required.
Great. I turn back to you. Anna, I see two questions there. So maybe in the interest of time, I would suggest we bundle them together. So Anna, and I cannot see who you are in this darkness there, but yeah.
Turn it on. So John Dingfelder-Stone from Rheinwald University in Germany. First of all, thank you for the wonderful presentations. I had a question to Kaya and Raphael. Your proposal about creating this single entity, I think it seems to operate under the assumption that, or I think it's necessary to make the assumption that a neutral entity can be created to sort of a neutral fact finder, you might say. And perhaps call me a cynic, but I worry that that's not necessarily a feasible possibility. And so I wonder about the risk-reward factor in this idea that there's sort of a second assumption that there's a necessity to do this for efficiency and funding reasons. And I wonder if maybe you haven't necessarily, well, not to suggest you haven't thought it through, but isn't there also a positive to be seen in multiple different entities with multiple different agendas coming at this from multiple angles and multiple interests on account of multiple parties, as maybe that's actually not a bad thing to get to the actual can, as we would say, of the matter? And to what extent have you really factored that in as this is or is this just an assumption that this is a necessary thing? I don't know enough about the overall system in its entirety to know whether or not it is that broken, but I guess I challenge that to a certain extent. Thank you, though.
Great, thank you.
Hi, Anna-Sophia Tiedeke from the Max Planck Institute for Comparative Public and International Law. Thank you very much for the super interesting panel. I listened very closely. And I think my question actually ties the past to discussion and the last question quite nicely. So listening to you, I was wondering whether there's a necessity to rethink curation and composition in evidence and also in court proceedings more generally. And the background of this question is not only your panel, but following the work of forensic architecture quite closely and seeing, for example, how critically German media and interestingly more progressive German media are actually reacting. I recently talked to a friend at the German press agency asking why so little of the work they are doing is being picked up in reporting, especially also on Israel and Gaza. And he told me that they only considered in the arts and culture rubric of their reporting. So I think this curation and composition element can also delegitimize this work. But on the other hand, digital evidence requires a lot more of actual and also visible curation, so for this evidence to be even understandable or legible for, for example, for the purposes in courtrooms. So I thought maybe we should consider curation and composition also in light of established things like witness training, for example, more fundamentally in order for also digital evidence to fit maybe better, or we can question certain kinds of practices maybe more pointedly. Yeah, but thank you very much. Super interesting.
Great. Yeah, that's a great question. And it's such a good example on how it would fall under the art section. I think it links really interestingly with what you say in terms of epistemological hierarchies and who gets to establish them and where lines are drawn. And if I could ask a microphone to still come to Delphine here in the front, because this party is truly getting started.
Thank you. This is inspired by Anna's great question. And it really, in line with her question, is a question about the politics of aesthetics. There's something where we talked about memory and how these events are told, right? So this is a long-standing discussion in criminal prosecution, especially international crimes. And I'm wondering how much of a thought aesthetics is in what the type of systems you produce, right? Because what we see are flowcharts, risk management aesthetics, managerial aesthetics that go into the evidentiary, right? Truth-telling, efficiency-driven type of convincing effect, as opposed to other projects like forensic architecture, who evidently have another type of narrative going on that is also very factual, very driven to truth producing, but with at least an appeal to producing beauty. I wondered if this is at all interesting to you. I'm not talking only in terms of beauty versus efficiency, but also the type of stories that these archives or these interoperable data systems are producing, like what kind of stories are we telling? And it goes back to what it will look like in 100 years. And so what is it? So digital data could mean different things. Is this notion of narrative or aesthetics part of the considerations you have when you think about these developments?
Wonderful. I'm going to add just a few lines to that and then pass it over to all of you for a 2 minutes kind of closure where you pick and choose what you do with that. But these three questions kind of link with the questions that I had prepared and which I didn't have to ask, to your great merit. but which link quite closely with what you had at some point, democratization on the first slide, right? Digitization, democratization. And a lot of these questions for me also revolve around democratization / decentralization / the whole citizen sensing move, the idea of kind of the redistribution of epistemic authority, who gets to make a truth claim. Does it have to be a certified, centralized archive? Does it have to be the kind of trial of the court where ultimately the sort of truth-telling narrative becomes authoritative? Or can we think of knowledge practices that are actually completely distributed and that have different kind of aesthetic dynamics, etc.? So I'm adding these 2 cents to it, but also maybe to bring the decentralization, democratization a little bit into that mix as well. I would ask you to stick to the time. So we have, again, the flashing. We have 6 minutes left, so I would say 2 minutes for each group, but that's not really fair for the 2 of you, so let's solve that situation in a decentralized way.
Okay, due to the time limit, we will just address some issues, but no, honestly, something that we didn't mention in our presentation is, and hopefully that answers some of the concerns raised, is that we don't really want to eliminate all the approaches, all the methodologies, and all the decentralized, democratized efforts. It's rather having seen how in practice those technical, very practical issues of, for example, for all UN mandates, every time building a new repository, so they have several repositories. Then ICC has its own huge thing, yeah? Then Eurojust, Europol have 2 separate databases within one international organization. And then we see that NGOs and different actors have their own narratives, forms, etc., which is totally okay. But once they want to actually transfer information to authorities, sometimes it's challenging because, first of all, authorities don't have practice and they don't know what to do with that. And this is, again, like the practical issue. We don't want to totally change the narrative, the shape of the information that is being, like, the whole picture of the information that is being collected anyway, because it is being collected. And probably your question about whether it's going to be open access, that worries me because we didn't make it clear. We don't want to do an archive that is a Wikipedia of what is happening. This is going to be a closed system where authorities that need, from Poland, Lithuania, Germany, whatever, ask for information, whether you have information as it is being done now, but they have to ask 10 different units. And I missed the last part, so sorry. Sorry.
Do I still have like a minute, or?
You have minus 10 seconds at the moment. Yeah.
I'll be quick. So in terms of digital evidence, there's some that's used in relation to mass graves in any event. For example, sort of satellite imagery is a way of identifying locations at the beginning, and there's ground-penetrating radar as a way of kind of investigating possible mass grave sites. But it's pretty analog, really, in terms of mass grave investigation, because that has to be done by real people. So it's and the evidence and taken out. So we had a PhD student who was developing sort of 3D modeling for mass graves, so you could, as a visualization tool to use in court. So I think there's definitely scope for it, which I think could be really, really useful. In terms of democratization, our aim of the mapping is that those tools can be used by anyone who's mapping mass graves for all sorts of reasons. So, for example, ICMP are mapping mass graves for, identification and legal processes, but there's also, for example, a community that was affected by a massacre in Uganda, for example, who have mapped what they described as that they experienced spiritual phenomena within a school setting where atrocities had taken place. It's probably what in the West we would kind of recognize as psychological symptoms as they revisited signs of atrocity. But they were mapped as a way of memorializing and remembering, and it was for them, done by them through with someone giving them some help. So it's hopefully been beneficial for them. There's the Balkan Investigative Reporting Network is currently mapping mass graves across the Balkan region as a way of countering revisionism. DCCAM in Cambodia also kind of mapping as well as a way of memorialization. So it's kind of serving a lot of different communities in various ways. And finally, just on the stories that we tell, obviously not every piece of work that we're doing at Magpie, the aim is to benefit the victims, but it doesn't always include the victims, if you understand what I mean. So we produced a couple of years back the Bournemouth Protocol on Mass Grave Protection and Investigation. And the idea was that it would benefit families of the missing so that they could have their loved ones found and returned to them. But the audience for it is lawyers and forensic practitioners. And so in response to that, in recognition of the fact that we didn't have a victim voice, we also produced a small animation, a 6-minute animation that we work with families of the missing from around the world, looking at the process of mass grave investigation from the perspective of families. It's non-verbal, it's 6 minutes long. It's not as horrible as it sounds, but we produce something like that because we're very, very conscious of that need to incorporate that balance too. And I'm really conscious I'm running out of time.
Thanks. In terms of the truth-seeking function and the amount of material being generated in digital format, I think for a movie quote, it reminds me of the Jaws, we're going to need a bigger boat. There's a need for these kinds of initiatives and thinking for how do we accommodate that volume of material. But then there's also in the modality of how we form truth as individuals, investigators, and also fact finders, a certain effect of the narrative way of describing an event. I think there is a tendency to always view things through a human chronological narrative, and that's always been the classic way that you'd write a witness statement. And digital evidence disrupts that somewhat because when you look at it, when you receive it, for instance, a file at the court, and it's a USB or some other format, it's almost unintelligible. It's nothing like that kind of account or story to deal with. So conveying that to the courtroom requires a certain curation in and of itself to try and make it make sense and to try and present it in a clear way. But you don't want to overdo that to the extent that you simplify or you cover over any slightly unclear points because the fact finder has to have the information. Where I think that more aesthetic value and that digestible quality can come from is really good drafting by the judges, and of course they're assisted by legal officers. Once they've looked at everything and they have formed a view as to what happened here, what they're satisfied by, if they can then repackage that into a clear chronological account of the major events, and there's some really good judgments about Srebrenica in the Karadzic case and Mladic, etc., where there's quite a clear retelling, albeit thousands of pages long, but you can follow the story more or less of what happened. So I think there's a real value there. And more importantly, in some ways, all of these other civil society initiatives, academic initiatives, where they have, I think, freer reign to present things visually, audio-visually, in other formats that can repeat and spread the word of what has been found to have occurred without having that obligation to be the fact finders and to have to ensure that every single word is precisely formulated on a body of evidence. So I think there is a value to that, but that has to be distributed democratically because I don't think the court can do it in and of itself.
Great. This conversation is clearly unfinished, which is beautiful to see. But for now, there's a temporary pause at least. Please join me in thanking our panelists for a really engaging conversation. And I should probably announce what's happening now, but